All right, this is case number 18-149034. This is Coleman Community College versus Kayla Boykin. The matter is before the court on petition petition in order to show cause. Your appearance from Coleman Community College. From Coleman Community College, do I have Kayla Boykin on the Zoom? If you're here, please say something at this time. All right, the court will revisit the issue of the motion to show cause. Doesn't appear that anyone is here, in which case the show cause would be dismissed. I'll recall it momentarily. The court now calls case number 22-192504. This is Gardner Properties Management LLC versus Maria Burnell. The matter is before the court on the set on for a status conference. This is the looks like the first hearing regarding this matter. All right, your appearance for Gardner Properties, please.
Good morning, Your Honor. Hamdi Sob on behalf of plaintiff P2080.
All right, thank you, Counselor. Good morning to you, sir. I'm looking for Maria Burnell in regard to this matter. If you're on the Zoom, please say something at this time. Ms. Burnell. All right, I did receive what's been offered as defendant's answer in this matter. Was filed on about the 16th of November, and the address, I believe that the defendant appeared instructed the court sent a notice of this hearing to the address provided by the defendant in this regard. Right. Counsel, have you had any opportunity to speak with Ms. Burnell? Any contact with her?
I have not, Your Honor. We haven't had any contact.
Once again, the court is reaching out for Maria Burnell. Matter is set on for 9:30. It's of course past that time. Counsel, your pleasure in this regard where the defendant has not appeared.
Your Honor, we would seek a default judgment.
All right, the court will enter the default of the defendant in this matter where the defendant has failed to appear despite having filed an answer in regard to this matter. The court will enter judgment on the default upon its proper presentment to the court. Right, thank you, Counsel. Good day to you.
Thank you, Your Honor. I believe I have one more with you. I'll stick around.
All right, just one moment, sir. Let me just, well, hold on one second. So it looks like, Counsel, that we have an address, looking back at the Burnell matter, the address that the case started under was on Evergreen Street. When Miss Burnell filed her answer, she indicated an address on South Metric Avenue. It looks like, just following up on some of this, it looks like the address that this notice was sent to was the address on South Electric, the address on Evergreen Street. When she filed her answer, she indicated a different address. We didn't catch that. So my inclination at this time is to stand down on the petition for entry of default. And I'm going to renotice this and make sure that it's sent out to the notice on Electric Street. And so we'll get this back here. So let me go ahead. I'm going to have to set it. I'll set it for the 5th of January 5, 2023. And that's going to be at 9:30 a.m. We're going to renotice it, set it up for that date.
Understandable, Your Honor.
counsel, what's the last three on the other one that you have, sir?
It is, I believe it's 9895, that Holdings LLC versus Martinique Allen. I believe Miss Allen is also here on Zoom.
All right, this is case number 22-189-895. This is Debt Holdings LLC versus Martin Allen. The matter is before the court, set on for a motion hearing. The court previously reviewed this matter and indicated that I would address the motion on today's day. I believe the parties were going to talk about this to see if there was a way forward. Counsel, enter your appearance once again regarding this matter.
Good morning again. Hamza Sob on behalf of plaintiff P2080.
Thank you, counsel. I'm looking for Martinique Allen. If you're on the Zoom, please say something at this time.
Martinique Allen is here.
All right, thank you, Ms. Allen, and good morning to you. Update me at this time, if you will, counsel.
Your Honor, I believe the last time we were here, the court adjourned this matter for the motion to be heard, but also gave an opportunity to Ms. Allen to respond to our motion and to file an answer that would respond to each and every allegation in our answer. And Your Honor, I don't know if the court has received that, but we haven't received any of that.
Yeah, and Ms. Allen, did you file anything subsequent? I haven't received any additional filing from you.
Yes, I did.
When did you file something, ma'am?
It was
Sorry, ma'am, what did you say it was?
it had to be around September. I want to say,
Yeah, I got that. But let me stop.
and then
Yeah. I got that. What I'm asking you is that the last time that you were here for the hearing, which was on the 14th of November, I told you that you could take the opportunity to, in fact, file a response to the motion that was filed.
the motion.
And did you file anything after November 14th? That's my question.
No, I already filed the motion to strike against the answer.
Well, I see that you want to answer the question by answering another question. I think the simple answer to your question is that I gave you an opportunity to respond to the motion to strike subsequent to the 14th and or to file an answer that addressed the issues in the complaint. Your answer to me is that you have not filed anything after November the 14th. Is that correct?
That's correct.
So, Mr. Counsel, so what is your issue with regard to the motion to strike, the answer in regard to this matter? So,
Well, Your Honor, the answer that we received wasn't really an answer that would comply with the court rules. It wasn't. It did not address each and every allegation in our complaint in numbered form. It was more or less just a paragraph explanation. And then also the other issue I have is we didn't receive response to our motion of summary disposition, our C10 motion. We haven't received any response to that. So at this time, Your Honor, we would request our motion to be granted based on failure to comply with the court rules.
all right, as it relates to the item submitted as a purported response to the complaint as an answer in this matter, the defendant has not taken the opportunity to give an updated answer with greater specificity. I will allow her answer in this matter at this time. I'll allow the answer. I believe that she's provided enough by way of the answer to put on notice as to what her defense may be regarding the claim that is brought against her. The greater challenge, I think, here is on the motion for summary disposition. The argument here is that she's failed to provide or state a valid defense to the claim. Tell me about your motion for summary disposition, counsel.
Well, Your Honor, it's very straightforward. This was a breach of contract. There was a contract in place, and a breach occurred where payments weren't made, obligations for payments weren't made, and our motion outlines that obligation, and it also explains all the charges that were listed in the ledger that was attached to the motion, and our motion basically states that there is no defense because one, it's a breach of contract, and two, there is no defense that came from the defendant. They must overcome the burden by documentary evidence. No documentation has been provided, and no response more so has been provided. That's what's really an issue. So our motion would go towards those two matters. One, it being that there's a breach of contract, so there's no defense to that, and it existed, and the defendant is not claiming it didn't exist. And two, she has failed to provide any defenses by providing documentary evidence to disprove any of the allegations claimed in both the motion and our complaint.
All right, thank you, counsel. Ms. Martin, Ms. Allen, what do you wish to say in this regard, ma'am?
I have responded to the allegations, and even from each section that was listed on the strike, I did write an answer to every last section. It should have been. Let me stop
you there. Let me stop you. I don't have a line by line answer to a complaint here. I don't. The complaint that was filed against you set forth specific allegations. I allowed your answer, but the complaint that was filed against you, the court rules, the court rule gives you guidance and direction that you are to respond to the complaint line by line, count 1, count 2, count 3, etc. And you never did that. So when you indicate here that you responded line by line, there was a complaint that was filed against you, and that complaint was a 17 point strike. That was a 24-point complaint, and you never responded to those 24 points, nor did you respond to the counts. The counts is count 1, breach of lease, count 2, breach of guarantee. So you never specifically responded, although I allowed your answer. So when you're talking to me and saying that you responded to every last one of those 25 or 24 counts, 24 points, you did not. But I've allowed your complaint. The issue here is what is the issue of dispute? It seems to me that you started out by saying that you were under contract with the plaintiff, and that there was an obligation that arose as a result of that. You were obligated to pay certain rental obligations during the term of the contract. Tell me about it.
Yes, I did enter into a contract from 2017, but it was a contract that I agreed to, but it also had damages. I could not operate my business at all from December 15th because the roofing was leaking, the roofing was caving in. So I could not at all operate out of the business.
All right. And so this was a commercial lease, of course, and under the commercial lease, it seems to me that this is not like a residential lease where the residence has to be in a state of repair in order for you to be obligated on rent on the residence. This was a commercial property, and typically the way that they're rented is that you rent the property, you bring it up to par to make it do whatever you wanted to do. Tell me how this was different than that.
So the landlord is responsible in section 505. The lease is 505. And he's responsible for the four walls, keep the.
Hold on a second, man. You broke up a little. You said, let me stop you for a moment because you broke up a little bit. You said under that provision, the landlord is responsible for the four walls, and then you were saying something else. Go ahead now. Yeah,
only responsible for anything that's operated inside of the building, which would be the furnace and just like keeping up the electrical and stuff that I operate off of.
Okay, got it. Council, Miss Allen is raising the issue that there were conditions that were the responsibility of the landowner as a part of this contractual agreement, and that creates a genuine issue of material, a genuine issue of fact.
Yeah, and the lease agreement also states in section 3.01 under Article 3, preparation of the lease premises, it says tenant acknowledges that the landlord has constructed the lease premises and the landlord has no further obligations, no further construction obligations hereunder. Also says that the landlord leases the lease premises to the tenant, and the tenant leases and accepts the lease premises from the landlord in its current as is condition.
In regard to the provision that Miss Allen made reference to, tell me what that provision says. I don't have it in front of me. I know I saw it.
Under what article was that again?
Miss Allen?
Section 503.
503. The common area expenses?
Yes.
I don't think a roof is a common area, Your Honor.
Yeah, well, why don't you rather slowly read that provision for me? Let me hear what.
Landlord agrees to maintain and keep in good service and repair the common areas at the reasonable discretion of the landlord, and the use of such areas and facilities shall be subject to such reasonable rules and regulations as landlord shall make from time to time.
And that's the provision that you're referring to, ma'am?
Yes.
Okay, anything else on the motion, Council?
Nothing further, Your Honor.
One moment, Mr. Council. Anything else, Ms. Allen?
I did on the November 11th, that was on a Thursday. I submitted another answer to that strike, and I also submitted photos and evidence showing that I was not responsible of breaking this lease.
Wow.
And that was on the Thursday.
All right, I received any items that you may have submitted to the court. I received photographs that you submitted to the court as well. And the document that you submitted is November the 10th, 2022. That's the court's timestamp. And you do have a lot of materials there. But what I wanted you to understand is when I told you it's undisputed that what I told you is that you didn't respond line by line to the complaint. That's just true. The fact that you provided the document that you provided, you provided a general statement, in fact, a one-page statement, and then you provided items with pictures that seem to discuss something that has to do with the photographs. But that's not providing an answer to the complaint. You never adequately responded, but I think that you raised enough of an issue that it put counsel or the plaintiff on notice as to what you might be defending in this case. So we're already past that. If you want to keep going back to suggest to the court, and I hope that you're not doing this, to suggest to the court that you answered point 1, 2, 3, 4 through 24. You did. You probably should have, but you did. And moreover, you did not respond in writing to the motion in this particular case. All right, you get the last word, if any, counsel.
Your Honor, I only have one other point to make. I mean, if Miss Allen's going to reference the lease agreement, there are multiple provisions in the lease agreement that point to the tenant having the obligation to maintain and repair any issues with the building. And then, for your Honor's record, it's section 6.01 under tenants obligations. I won't read it. It's a pretty big section, but it does provide for the statement that says that tenant is obligated to perform these kind of repairs, whether it be to the roof or any structures outside of the building. And it does say that it's at the tenant's expense. For other than that, Your Honor, I wouldn't say I have anything further.
All right, thank you, counsel. All right, I've listened to the arguments with regard to the motion for summary disposition in this matter. And the court has already previously made its ruling with regard to the motion to strike the answer. I've allowed the answer in this case, although I've already stated the various caveats that may have application going forward. And that is that it obviously was not an answer line upon line in congruence with the court rules provided in such cases. But I think the answer is sufficiently planned to put the plaintiff on notice as to what the defense may be in this regard. On the motion for summary disposition, there is a general proposition, of course, where there is a commercial lease type situation that the person leasing the commercial property has the obligation to conform the property to what their desires and intents are, and to make it usable for that particular purpose. The document speaks to those kinds of issues. What the reality is having listened to this matter, it appears that the document is not clear and unequivocal as to who those obligations inure to when it comes to the repair of the roof. There is a provision that clearly sets forth some obligations that rest on the part of the plaintiff. Essentially, what this comes down to is that there clearly is a question of fact. There is a genuine issue of material fact for dispute, and that issue should be resolved. That should be resolved by a factual determination on those issues. Ultimately, it's a mixture of factual and legal issues, and the court at the appropriate time can render a determination as to the application of the legal, or strike that of the provision of the lease, which is a legal determination. But there seems to be a genuine issue of material fact for a dispute as to what the terms of the contract actually meant and how they apply to this particular situation. For that reason, the motion for summary disposition in this matter will be denied at this time. So I'm going to go ahead and set this up for a pretrial conference to see if we can narrow the issues a bit more and then decide whether or not this should be put to a trial. All right, so the next action date in this matter is going to be, strike that. I'm going to go ahead and set this up on a discovery schedule. And so I'm going to, just one moment looking at a calendar. Just one moment. All right, so the return date on this matter is going to be the 9th of February. The 9th of February, and that's going to be at 9:45 a.m. That's 2/9/23, 9:45 a.m. You're going to get a scheduling order from me in the mail. That scheduling order is going to set forth the fact that discovery is open through the 9th of February. Any information you want to exchange, you want to acquire, you want to send out discovery, you must do so during the period of time that's allowed in this window. I'm setting a pretrial conference date thereafter. You will see in the order under paragraph number 6 that it does allow the filing of motions, dispositive or otherwise, and those motions can be set for hearing on the 9th of February. The only requirement is that you allow the other party at least 10 days to respond to your motion. If you file your motion, give the other party 10 days to respond. I will hear that motion on the 9th of February 2023 at 9:45 a.m. All right, that is the order in this case, and I will issue an order with regard to the motion that was filed, as well as an order setting out the pretrial issues regarding this case. You'll get that from me in the next few days. All right, I wish both sides well. Good day to you.
Thank you, Your Honor. Have a great day.
All right, ladies and gentlemen, thank you for your patience. This is case number 221951904, Motor Credit Company LLC versus Abdul Mohammed and Diane Burt Mohammed. The matter is before the court, set for a status conference. Your appearance before Motor Credit, please.
Good morning, Your Honor. Robin Stradowski on behalf of Motor Credit Company, 7P number 71195.
Thank you, Madam Counsel. Thank you for your patience. Let me hear now from counsel for Mohammed, please. Your appearance, please.
Sorry, Your Honor. John Ivanchik on behalf of both defendants, Abdul Mohammed and Diane Burt Mohammed, P66157.
Thank you, counsel, and good morning to you, sir. All right, have the two of you had an opportunity to kind of talk about this at all? Or,
Yes, we have, Your Honor. I believe we've come to a resolution. We would just ask the court to adjourn this matter maybe for about 45 days, which would give us time to receive the payment that we've agreed upon and also to file a dismissal.
We're in agreement with that, Your Honor.
all right. So now I'll do that. Here's what I like to do. What I like to do is I like to enter a conditional order of dismissal for automatic reinstatement, and then set a 60-day period for reinstatement. Does that make sense to you? I'll do it your way, but kind of if I go ahead and dismiss it, you have 60 days to reinstate it. Either party would simply either party would send a notice to the court saying the matter is reinstated where the agreement the parties not find it resolved.
If that's how you'd like to handle it, Your Honor, that's fine with us. Would that be a dismissal without prejudice then?
Dismissal without prejudice. And what would happen is after 60 days, it will become a dismissal with prejudice.
If that's okay with Mr. Ivanchik, that's fine.
I have no objection to that, Your Honor.
All right, so I will issue such an order. You get such an order from me, and of course, if along the way you get it resolved and you send in something indicating that the dismissal with prejudice should apply, then we'll bring it in closer than the 60 days out. Otherwise, we'll have to do else. It'll just turn into a dismissal with prejudice after 60 days. All right, I'll get such an order out to you. You get it in the next couple of days. Okay, I wish you well.
All right, thank you.
Your Honor.
All right, the board now calls case number 22-195-205. This is CKS Prime Investments LLC versus Lawrence Gardner. The matter is before the court, set on for a status scheduling conference. So the court having received the answer of Lieutenant Gardner, the court again set it on for the status conference. Your appearance for CKS Prime Investment LLC.
Good morning, Your Honor. Michael Bankstein, P69778 on behalf of CKS Prime Investments.
Thank you, Mr. Bankstein, and good morning to you, sir. Let me see if I have Mr. Gardner here or counsel for Mr. Gardner say something if you're here. All right, Mr. Lawrence Gardner, if you want to Zoom anywhere, if there's any counsel representing Mr. Gardner, please say something at this time. Just one moment, counsel.
I had Mr. Gardner on the phone.
All right, Mr. Gardner did call in.
No, he's Zoomed in. He's on by phone. He should be.
Well, he says, my clerk is advising that he's somewhere on here.
At 1488. That's the next.
All right, yeah, I do see him there. Mr. Garner, we're calling for your case right now. I'm gonna go ahead and chat him there and see if get his attention. All right, now, let me ask you, Council, have you had a chance to talk to Mr. Garner? It looks like he's there on that number, but he's not responding. Was there any opportunity to speak with him at any time?
I have not had
Yeah,
an
I'm here.
opportunity. I have not
I'm
had
here.
an opportunity. I'm sorry, I just can't answer your question, Your Honor. You won't stop interrupting.
Okay,
Yeah,
that's all
there was the gentleman said something when you started talking. The moment that you started talking, Mr. Garner said something. So let me see if I can get to him. Council, I'll come right back to you, sir.
Thank you,
Mr.
Your
Garner?
Honor.
Mr. Garner, you there, sir?
Yes, sir. I'm here, sir.
All right, I can hardly hear you. The attorney on the other side of this is present, and this is set for a status conference today. I did receive your answer. And it looks like what you're saying that you don't have any resources. That's basically what your response to the complaint has been, correct?
That is correct, sir.
All right, let me hear from the attorney on the other side of this, and then I'll come back to you, sir. Go ahead, counsel.
Thank you, Your Honor. We did not have a good phone number for Mr. Garner. I did jot down that phone number that I'm seeing on the Zoom panel. I think given his answer that basically he doesn't deny liability. He just says that he can't pay. I think it's probably not likely that he's willing to entertain settlement, but certainly if he makes me an offer, I'll entertain it.
All right, Mr. Garner, were you able to hear the attorney for CKS?
Yes, sir.
I know it's a little bit of a challenge, but I want to put the two of you in a breakout room and see if there's any room to talk here. It sounds like that you're not really challenging that there is an obligation here, but what you're looking for, or what you're pointing out is that you don't have the ability to pay on it. So let's see if talking about it for a few moments you might be able to come up with some amount that maybe you could reach an agreement. If not, then we'll look to another way to do this. I'm going to give you just a few moments to go and speak with the attorney on the other side to see if you can get to any resolution in this matter. But again, it doesn't seem to me that you are raising any legal or factual challenge to the complaint. So let's try to do it that way for just a moment here. And I'm sending you a notification, so go ahead and click into that breakout room, and counsel is going to speak with you regarding his client's position as well.
Thank you, Your Honor.
Counsel, when you come back in, I'll come back to this, sir. All right, the court now calls case number 22-196-461. This is Beaumont versus Barbara Harper Long, or Barbara Long Harper. The matter is before the court, set on for a status conference. The court may receive the following of a document offered as an answer. That document points out that the defendant is on disability. And so that's a challenge that was brought in by way of answering this matter. For the record, your appearance for Beaumont Health, I'm sorry.
Well, Your Honor, Hal Burke, P69068, attorney for Beaumont Health on this case. Thank you.
Thank you, Ms. Burke, and thank you for your patience this morning, sir. I'm looking for Barbara Long Harper or anybody representing Ms. Harper. If you're on the Zoom, please say something at this time. If you're on the Zoom, please say something at this time. All right, looks like I'm not getting any response from Ms. Harper. And again, as I pointed out, the answer basically says I'm off work on disability. and I've been off since 6/21. She says I can make arrangements to pay $60 a month. I'm only receiving 70% of my pay. It's not enough. So there's not a dispute as to the obligation. Defendant wants to pay $60 per month towards satisfying the obligation. Counsel may.
Your Honor, I respect that. If you'd consider a default under the 7-day rule and within that time, including right after we log off, I will have her contacted again. We did attempt to contact her and did read her answer, and maybe she and I or she in our office can get her on a payment plan she accepts.
All right, on your petition, I will enter the judgment by default upon proper presentment, and the court would find on its face that the complaint is basically, the answer is an admission to the claims and a plea for an installment agreement. The court takes the petitioner's installment petition under advisement. She's requesting the opportunity to pay $60 per month. I'm going to take that under advisement, and I'll allow counsel to communicate with the defendant regarding a payment amount. If they're not able to resolve that, the court will take up the $60 a month petition. All right, so the default is entered for the reasons as indicated on this record, and I will await your order in this regard. And as I said, the $60 a month petition for installments is taken under advisement. All right, counsel, send your order in. Good day to you.
Thank you. Have a great day. Thank you.
All right, I'm looking now to case number 22-184-950. This is AutoVest LLC versus Maya Perkins. The matter is before the court. I believe this was before me on one other occasion. There is a pending motion for a summary disposition. Answers have been filed regarding this matter. Your appearance for plaintiff in this regard, please.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
All right, thank you, counsel. Good morning to you. For defendant Perkins in this matter, your appearance at this time, counsel.
Yeah, good morning, Your Honor, and good morning to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Ms. Perkins, also with authority to, I would leave it to Brother Counsel to make representations to the court, which I believe we have an agreement. It hasn't been put into writing, but I'll leave it. I'll turn it over to Brother Counsel.
That's correct, Your Honor. We spoke before the hearing, and we've come to an agreement whereby we're going to enter into a conditional dismissal, whereby the defendant agrees to pay the sum of $7,760.71 in monthly installments of $100 a month, starting December 15th.
And furthermore, Brother Counsel said he would send me a link today so that I could pay my niece's first payment. So it'll be her Christmas present, but nonetheless, that's accurate statement on behalf of Brother Counsel.
All right. The court then will adopt the agreement as the resolution regarding this matter, and I will await the order of dismissal, the order of conditional dismissal from counsel. Let me give you an address. Let me give you an email address where you can send that in. I can get it signed up right away. That is Carmen, C-A-R-M-E-N, Carmen dot last name Banks, B-A-N-K-S at 36districtcourt.org.
And Mr. Perkins, do we have permission to sign on your behalf for this matter?
You do. And you don't have to wait to, like we were talking earlier, just send me the link. I don't have to wait for the court to sign it. I just want to get that out the way.
Understood.
All right.
That's a part of the, I can remember some of those days, that's a part of the cost of representing family is that at times you get the blessed benefit of not only representing them, but also carrying the water a little bit too.
Yeah.
Yes, you're preaching, Your Honor.
Well, I'm glad it got worked out. The file will be noted accordingly. It's good to see both of you and best of the holiday season too.
You as well.
Thank you so much, Your Honor. You as well.
Thank you.
Mr. Bankston, I see that you're back, sir. Looking to see if other side, Mr. Garner is back. I don't see that he's made it back yet. Yeah, looks like he's still stuck there. Can you kind of tell me, did you get anywhere? Did things get worked out at all? Or?
We were not able to reach settlement. We're going to need 60 days for discovery.
Okay. All right, sounds good. All right, so I'll go ahead and set it up that way, counsel, and I'll make sure that things get mailed out. So I'm going to go ahead and set it for all the way to February. We have to look at different type of calendars and stuff. So I'm going to go ahead and set it up to come back on the 9th of February, 29, 23, and that's going to be at 10 o'clock a.m. And you'll get a discovery order from me that allows discovery through that date. And also it has a provision for filing motions under paragraph number 6.
You said February? I'm sorry.
I'm sorry, sir. February 9th, 2023. That's going to be at 10 o'clock a.m.
Thank you, Your Honor.
All right, thank you. And if you could go back and I'm going to send this out in the mail, but if you can go back and connect to the gentleman, he's still there, and just let him know what's going on. Although we're going to mail the date out.
When you say go back, are you putting me back in the breakout room?
Yeah, I was gonna. Now you should still have the invite to click back in yourself, just to let him know what's going on.
I don't see a second invite, Your Honor.
Okay, well let me do it. Let me do it that way.
My impression is when someone leaves the breakout room, the initial invite is no more.
No, it's still there.
I just don't see it.
All right, not a problem. There's a way to go back and I'm not exactly sure how to tell you how to do that. So I'm gonna send you to 2, and then I'm gonna flip him over to 2 as well.
Thank you, Your Honor.
All right. All right, this is case number 22-185-742. This is Citibank NA versus MDZ Khan, KHAN. The matter is before the court set on for a pretrial. I also have the filing of a motion for summary disposition in this regard. All right, your appearance for Citibank, please.
Good morning, Your Honor. Preston Nate, P77884, appearing for Citibank.
Thank you, counsel, and thank you for your patience this morning as well. I'm looking for, I don't know if that should be Dr. Zihan or MD Zihan, whichever way it is. I'm looking for that person now. If you're on this Zoom, please say something at this time. Doesn't look like I'm seeing that person. Counsel, have you spoken with that individual recently?
No, and I think he or she, I don't know, is being represented by an attorney, Socorro Henry. But I haven't had any contact from her office either. I know we had a hearing back in September where we granted discovery, but that's kind of been the last thing. I did try to reach out to her. I haven't heard back. So no, I don't know where her position is now. Unfortunately.
So you made some phone calls to try and reach out and find out what was going on, correct?
We typically email each other. We have other cases with Socorro. It's not, we work pretty well together. I haven't seen her anything from this particular case. So.
All right, Council, I don't like it when lawyers don't show up for their date. I see several filings by her. So what's your thoughts or pleasure in this regard?
Well, I'd be inclined probably to continue with the motion for summary. If granted, I don't like to just default or get a motion on another attorney. Maybe she didn't get noticed, but maybe under the 7-day rule would be appropriate. But I would be inclined to not waste the court's time further, to continue with the motion and maybe submit that under the 7-day rule. Give her one last chance to maybe to kind of respond or reach out to me.
That sounds reasonable. Let me hear what your challenge is on the motion for summary disposition, sir.
Okay. Thank you.
Very good, Your Honor. Plaintiff would move the court to grant judgment under the motion for summary disposition that was filed 2.116C 9 and 10. Based on the answer that was provided, it doesn't seem like there's any really issue of material fact or valid defense really that would require a trial to be held on this matter. The plaintiff is asking for judgment in the amount paid for in the complaint, $2,290.30, plus the court costs, so $75 filing fee, $49.92 service fee, and a $20 motion fee, for a total judgment of $2,435.22. And that, of course, at this time, if judgment is granted, we would request that maybe we submit that under the 7-day rule to allow opposing counsel another opportunity to maybe respond.
Counsel, I am not. I don't see in the file a written response to the motion for summary disposition, although the court received the motion in October 7th. I have not received a written response or anything in opposition to the motion. Have you received a written
we didn't we didn't receive a response to the motion either, just the answer that was filed to the complaint.
All right, under the under all circumstances here, where there's not been a written response to the motion, and where the motion seems to be set forth on solid grounds, the court will grant defendant's motion for summary disposition, finding that there is no genuine issue of material fact that the plaintiff is entitled to judgment as a matter of law, and the court will sign an order consistent therewith. I would anticipate that order be submitted under the 7-day rule. Given the circumstances of this case, where there is an attorney on the other side who has not appeared today, now review the order on the submission. The motion is granted.
Very good, Your Honor. Thank you. We'll get that prepared and into the court.
Thank you, counsel.
You bet. I think that's it for me. So you have a good rest of the day.
You too. In regard to the suffix 9034, Coleman County Community College versus Kayla Boykins, neither side appeared in this matter. More significantly, the applicant on the show cause did not appear. Accordingly, the show cause at this time will be dismissed. All right. All right, Madam Reporter. Thank you again.
Oh, sure. I didn't know we were done. Okay, I thought we still had someone in recess. Okay.
I think that's, let me just check. One. Yeah, I think that's a wrap for us. Not,
Okay, Lawrence Gardner. Okay.
I know.
all right, that's a wrap, Ms. Burgess. Good day to you.
Okay.
All right,
Thank
have a great one, Madam
You
Reporter.
too. See you tomorrow.
All right.
Okay.